Any more homeowners that want to get on that speak? Good morning.
Good morning.
How are you?
Yes, sir.
Gentlemen, board members, it's approximately 9:15. We do not have a quorum. We will wait approximately 54 minutes to see if we can achieve a quorum.
So much stuff like that.
Good morning, ladies and gentlemen. We now have a quorum. I'd like to call the meeting to order and have a roll call.
Jack Moore, residential contractor.
Mike Rose, multifamily.
Robert Hanley, architect.
Ronald M.J., electrical engineer.
Chris Garcia, mechanical engineer.
Edna Geckler, Building Owners and Managers Association.
Liddell Toy, master sign electrician.
Tim Curley, master electrician.
Ron Cactus, master electrician.
Thank you. The time now is approximately 9:41 on May 29th, 2015. The Building-Related Fire Code Appeals and Advisory Board of the City of San Antonio will now convene an executive session pursuant to Texas Government Code, Attorney-Client Consultation, Section 51.071. We will adjourn to the meeting room at our left. You know what?
Oh, okay. They can clear that. What happened?
We're at the meeting and it's approximately 7 minutes till 10. The members of the board are in executive session and have been so for approximately 10 minutes. We're still waiting to begin the meeting. Thank you. It's roughly 10:03. They're still in executive session meeting with Attorney Ted Murphy. And we're still waiting for the meeting to begin. Thank you.
I need the yes.
Yeah, I know, that's how I just looking for it.
The time is now 10:14 a.m. on May 29, 2015. The building-related fire codes appeals and advisory board of the city of San Antonio will now convene in open session. No official action was taken in executive session. Also like to mention that Mr. Randy Hunter, who is a board member, is now part of the board for purposes. We'll return to the next order of business on the agenda, and that's approval of the meetings of the last minute held on May 9th. Is there a motion?
Robert Hammond, I move approval of the meeting minutes from May 9th.
Garcia, I'll second the motion.
Are there any comments?
Mr. Chairman, on notice that Mr. Leonard had brought up a definition of a clinic. Discussion that's not listed. I'll call the exact number of the article is usually when it was brought up. It's not reflected in the minutes.
Amy, can you check the recording and adjust the minutes accordingly? With the pending addition of the comments by Mr. Leonard, does anybody have any objections to approving the minutes? It's been moved and seconded. Vote. All in favor say aye. Aye. All opposed, nay. Minutes are approved with the amendment of Mr. Leonard's comments. Procedure we'll follow today on hearing this appeal is that the city will respond to the appellant. The appellant will have an opportunity to present their side of the argument, followed by comments from the public. Those that are signed up to speak will be allowed 3 minutes to speak. You may not pass your time off to anyone. After the public has spoken, we'll hear a summation by the city, and the board will take action. Mr. Shannon?
Thank you, Mr. Chairman. and members of the board. For the record, my name is Mike Shannon. I'm the Assistant Director with Development Services, and I'll kind of present the city's information on the appeal today. One housekeeping item I'd like to ask. There are two actual appeals that were submitted that we're hearing today because there are two separate plumbing permits. You'll note that many of the arguments that are presented, or if not all the arguments presented for both permits that the appellant had submitted to us are identical in terms of their reasons for appealing it. I just want to know if it's appropriate or recommend that we talk them all together. I think that would be most appropriate to streamline this process. And I just want to know if that's anybody can handle it.
I don't think the board has a problem if the attorney representing the appellant has a problem.
No, Mr. Chairman, we don't.
Thank you. So we'll hear the arguments concurrently.
Well, thank you. We're here today because there was an appeal of two plumbing permits that were recently issued towards the end of a project under construction here in the city at 2140 Babcock. So many of you that were here a few weeks ago, there was a similar appeal on electrical permit, completion permit, and we went through a lot of comments, but certainly not all of you are here. So what we had at 2140 Babcock was a project that was permitted through the city's plan review process, and a building permit was issued for that project back in August of 2014. And then it had several months of construction, call it 7 or 8 months of construction. And typical, very typical to all of our projects, whether it's a new or renovation project, the city reviews the proposed project, the design, the construction documents at the time with our plan review staff. When it's determined that it meets the city's codes, and that could be the building code, the fire code, zoning regulations, traffic standards that are applicable to the project. If we believe it meets code, we issue the building permit, which was done back in August. So this particular appeal is appealing two separate plumbing permits. So we're all, I think, familiar with how plumbing permits and the other trade permits are issued in our system, which is very similar to other jurisdictions. Once the design from the engineers, architects, and other design professionals is approved, we have licensed contractors, mechanical, electrical, plumbing. In this case, plumbing contractors. They pull separate trade permits, and the trade permits are such that they would actually install something as part of the design or a piece or a trade piece. In this case, there were two permits issued to Lindig Plumbing, which is a licensed plumbing contractor registered with the city, and they were going to issue. One was for a gas opening, and the other one was for a water heater as part of this project. Very similar to if they were pulling the general plumbing permit for the any type of water lines, sewer lines, anything like that. Same with mechanical and electrical, maybe the same. These two permits were actually issued through our web portal. Our web portal is a system that some of you as contractors have used in the past. That's a way where the contractor goes online, and that system actually verifies that they're in conformance with several things, that they're legal, if you will. The issue is, are they associated with an approved building permit, meaning that the city has already reviewed the proposed project? And the answer is, of course, yes. This project was permitted back in the August timeframe. Through the web system, it also verifies that these are licensed, registered contractors. We have our city code in Chapter 10. Our trade contractors, mechanical, electrical, plumbing, and some others, they're required to be registered with us. They're required to have a state license. And there are other things to be properly registered, adequate insurance, those type of things. And that's how that's handled. So the web portal verifies all that. They pull the permit, they tell us what they're going to install, and those permits are pulled over the web. And the majority of our trade permits, our child trade permits, are pulled that way on commercial projects. So it's very typical. So we're here today, again, the question at hand were those permits issued properly or not? And what was presented to you in the packet from the applicants, very similar to what was presented last time, which is they're going to want to argue zoning. They're going to want to argue other things, traffic standards, those type of things, and how this project, in their minds, doesn't meet those. Of course, the city, we disagree with that, and we've talked about that previously, and we can talk about that again, because we issued the building permit on that back in August. But what the applicant is choosing to do is trying to get this board, which is our Building Related Park Field Advisory Board, to make a zoning call. And as you heard last time, many of you heard last time, that's not appropriate. Chapter 10, you all here are to decide appeals in Chapter 10, which is, of course, most of the building-related codes, building, electrical, mechanical, plumbing, so on and so forth. Chapter 11, which is the fire code, and some of Chapter 28, right? We specifically call out the sign ordinance. There are some things in the sign ordinance that this board handles, some things that the Board of Appeals handles, if there is a question of a decision. So there is, again, there's going to be a lot of discussion because much of what was presented to you is the same argument that was presented a few weeks ago for the electrical permit, again, which the board actually chose to uphold the city's decision, the building commission's decision, that electrical permit was issued properly in accordance with Chapter 10. And but the plumbing permits, again, are going to be very similar. They will reference some of the references in Chapter 10, specifically a couple of them that they will argue, and they have argued in their write-up. There is a reference to, and let me grab my notes here. There are a couple of references we need to consider. So Section 10-14 of the Building Related and Fire Code Appeals Advisory Board, that's the one that talks about you guys and gals. So that's what it says. A building related and fire code appeals advisory board, this is subsection A, is created, and the board shall hear and decide appeals of orders, decisions, or determinations made by the building official or the fire chief relative to the application and interpretations of Chapter 10, Chapter 11, and specific articles in Chapter 28. I just referenced that. So it's very clear that our city code tells you all that you can hear things related to technical items, right? The technical construction codes. That's why we made up the panel of 17 specified disciplines with alternates, of course. So what they'll also talk about, though, is a general talk about permits. The code further goes on and says the building official shall review it, and I'm looking at subsection K of that, section 10-6 under permits. Talk about subsection K. The building official shall examine or possibly examine the application for permits and amendments thereto. We review building permits. We certainly issue and review trade permits through various means. But it talks here is the building official is satisfied that the proposed work conforms to requirements of this chapter and applicable laws and ordinances, and that fees specified in ordinances adopted by the city have been paid, the building official shall issue a permit for the work as soon as practical. That's kind of the catch-all that they argued last time, and they argued in their write-up here, and we'd like to go argue again. That's a general idea that says if the building official is reviewing a permit and issuing a form permit, he should make sure that they meet all the applicable codes. It's kind of a catch-all. But as you can imagine, we have done that. The city has done that. We did that through the plan review and permit process back in the summer of 14, if you will. We issued it in August, like I said. The child permits, to come here and argue that we issued a child permit incorrectly because of zoning is, in our opinion, certainly way off base, not the purview of this board. But it's just inaccurate, too, because we've already determined that it's appropriate in the applicable codes and standards. But if you were to take this argument even further, I think I mentioned some of this a few weeks ago to some of you who were here, but those that didn't hear it, that would be like us saying if it doesn't meet a federal EPA law or an accessibility law or those type of things, that we shouldn't issue a plumbing permit. Those are not under our purview, right? Certainly, if it doesn't meet something that's under our purview and we know about it, we would investigate that and evaluate that. But then we would have that argument with anybody who disagrees with us, which we would. And then, of course, if we had that argument, we would go to the appropriate appeal and due process body to make that argument. Of course, this is not that board. So I'm going to just kind of leave it at that we have issued, or we did issue 2 trade permits. These are child permits to the overall building permit. Very typical stuff, a water softener and a gas opening. Those permits were issued to licensed, properly registered contractors, a contractor here in the city of San Antonio. The work actually has been reviewed and inspected, of course, and made sure that it meets the code requirements, not only the people that are doing it, but the work itself was in conformance with code. And those permits have been closed out as plumbing permits, so they have to run the gamut through the process. So I just ask you to review what's in front of you. And certainly, again, did the plumbing permits get issued in accordance with Chapter 10? We certainly think that we know they were, and we'd just be happy to answer any questions.
Any questions, Mr. Shannon, from the board?
Garcia. Mr. Shannon, when the design came through for the plumbing, was that reviewed and found to be in compliance with the current applicable codes for the city of San Antonio?
Yes.
When they issued the permit, does that trigger any inspections from plumbing inspectors from this department?
So what will happen is when we issue the building permit, before they get any inspections, the actual licensed plumber, because we have to ensure that before someone does plumbing work, and you can say this about electrical and mechanical and some of the other trades, the people that physically do the work have to be licensed and registered plumbers in this case. So the plumber has to pull a permit, a separate child permit, which they did well before many of these. So there's several plumbing permits on this project, which is not uncommon. So after August, there were several plumbing permits pulled, as well, other trade permits, to do that work, and then the inspections are attached to that plumbing permit. As we're also getting permits under the parent, inspections under the parent project, you'll typically get in your building inspections. You might be getting your fire inspections under those, but the trade permits come under what we call this child permit. That's because that is our system, right, of ensuring that we have licensed individuals doing the install work. And as an engineer, you certainly know that you would design the system, and then a licensed person would install the system. So,
It sounded like you had said this work had already been inspected. Is that correct?
as of today,
Yeah.
the permits were pulled, and then the work was done, and then it has been inspected.
Okay, so the work's already been completed and it's been inspected, correct?
Correct, because these permits were pulled in April, near the end of April. I think it was the 24th. I can check my notes on that.
Okay, and so the work past inspection was found to be compliant with the current codes?
Yes.
Okay, thank you.
Mr. Chairman? Mr. Shannon, were those plumbing permits, were they tied to the building permit?
Yes.
Any other questions for Mr. Shannon? Thank you, Mike.
Thank you.
Good morning, Mr. Chairman, members of the board. I was in front of a number of you last time. My name is Dennis Driar, and I'm one of the lawyers representing appellants on this matter. Mr. Brad Wheeler is also another lawyer, my co-counsel representing appellants. Last time I began by talking to you, thanking you actually, regarding your service to the board, in particular because it's a citizen board, and I talked to you about that, and again, we appreciate it. But last time, Mr. Mike Shannon and Mr. Ted Murphy were actually advocating a process and procedure for the board. Since the last hearing, I had asked Mr. Murphy for what's the process and procedure for the board. We recently obtained from the city, in what I call a Public Information Act request, the Attorney General still references it under old law called ORRs, or Open Records Request. What we understood to be the process and procedures for this board. And if the board would be kind enough to just give me a few minutes so that I may try to point out some housekeeping matters. Mr. Chairman, may I approach? Mr. Chairman, members of the board, this was not easy to get. I have argued before intermediate appellate courts in the state of Texas. I've argued in federal district court. I've tried over 150 cases. I have appeared before state administrative hearings before. I've appeared for appraisal district hearings before. Rules are often published for the process and procedure. And when I'm faced with an opposing counsel or an adversary, or even an advisor for a board, it should be regular due process just to say, here are the rules. It should not be like pulling teeth. Respectfully, these rules that we were handed actually comport with constitutional process because we have been told that we have burden of proof. In most courts, in most administrative processes, the party with the burden of proof also goes last. It's not the party without the burden of proof who goes last. And so I respectfully would ask, Mr. Chairman, that we be afforded an opportunity to rebut the city's position, not that the city is afforded an opportunity to talk about a position after we have already had to sit down. And I'll leave that for the chair and the board's consideration. But there are some other housekeeping matters to talk about. And so respectfully, Mr. Chairman and members of the board, if there is process or procedure being used today contrary to what I just handed out, we respectfully would be objecting to that. The city has attorneys. I know Mr. Ted Murphy. I know Mr. Norbert Hart. I know a number of the attorneys that used to be some of my fellow colleagues when I was in the city attorney's office. And they have some new lawyers I don't know. But let me give you a hypothetical. A number of Americans have to face divorce. It's unfortunate, it happens. Say any of you are facing a divorce and your spouse goes to hire a lawyer. And then you get to court and your spouse's lawyer isn't just opposing you, but is representing the judge. That's what we have here. Or say you have business operations, maybe a business dispute of some type, and you have to hire counsel. Go to court, and guess what? Your opponent or your business partner, whomever you're litigating against, that lawyer walks into court and says, Judge, let me switch hats because I'm going to represent and advise you while I go and I argue against this party here. Respectfully, it doesn't feel good, but that's what it feels like to us. The city attorney is serving as an advisor to you and is also advocating against us at the same time, serving as an advisor or attorney for the judges. Now, I want to be fair. There are Texas disciplinary rules of professional conduct that govern lawyers, govern the conduct of lawyers. All lawyers are bound by that. And there is a process to go ahead and create firewalls within a department so that something like that can happen. The easier thing to do is just to get outside counsel. That would be the easiest thing to do. I don't know if that's being complied with, but it doesn't feel good. And so respectfully, to the extent that the city attorney is serving as an advocate against us and advising you, we respectfully object. Last time, there was a vote taken, and I understand, Mr. Chairman and members of the board, that you can only do that which is advised by the legal department or counsel for the board. There was a vote taken, and it was a vote regarding what to do with the building official's decision. In fact, I believe Mr. Hanley had made that particular vote, and it dealt with the appeal specifically on Laurie Rojas. Respectfully, it was not a vote for a resolution. And so what I'm going to ask today, Mr. Chairman, is that whatever vote is taken today, is that it be a vote for a resolution to do whatever is going to occur. Because the vote should pass a resolution, and it shouldn't, the board should pass a resolution as a whole. It shouldn't be a voice vote, and then later there's just some resolution proposed by a city attorney somewhere that's signed off on. So what I have here is I have proposed resolutions we'd like you to consider. And I have one for each permit. I will hand one to the city. I'll also hand one to Council, Mr. Murphy. Mr. Chairman, if I may approach. Chairman, members of the board, what these proposed resolutions are doing is they are proposing to overrule and reverse the decision of the building official on these particular two permits. And they are doing so for some of the reasons we talked about last time. But if you would permit me, to go through a few items. Mr. Shannon told you that he believes we're at the wrong board. I will tell you what I told you last time. Mr. Shannon's department, Mr. Sanchez's department, is the one that sent us here. We have asked and they have refused to forward and set our matters for the Board of Adjustment. In the law, you have to come to court or to a tribunal with clean hands. You can't go with dirty hands. You can't go and say, well, they're not doing what we think they should do, and we're preventing them from doing it. He didn't tell you that to you. He did not tell you that there were multiple attempts to appeal to the Board of Adjustment that his department denied. He just said, well, you don't have authority to be here, is his position. So let's talk about that authority. It is set out in our letter that's part of our appeal. And very shortly, we're going to ask to call witnesses to talk to them about certain items. But one of the things that is clearly set out is at 10-6A, an owner or authorized agent is the one that is going to be required to apply for a permit. Well, that's interesting. So what is a permit supposed to look like? What is it supposed to have on it? Well, it's supposed to identify the use. Chapter 10 specifically references that it's supposed to identify the use and occupancy. That's what it's supposed to do. Mr. Shannon would have you believe that that's pretty meaningless. I apologize about that. Mr. Shannon would have you believe that that's meaningless. And yet the City Council wrote what I guess Mr. Shannon and his colleagues in the Development Services would consider meaningless. They wrote it into Chapter 10 of the Code. They wrote into Chapter 10 that before you pull a permit, an electrical permit or a plumbing permit or any other permit, you're supposed to identify the use and occupancy for what that permit's going to be used. That's what's in the code. That's what we're cross-referencing specifically in our letter, and we're citing into the sections of the code. So what is Development Services? What's the building official supposed to do when they get this? Well, they are supposed to look at that application, and they are supposed to see if it meets the requirements of Chapter 10. That's true. But any other pertinent laws. Now, if you look at our letter, Mr. Shannon was referencing laws under their purview. We suspected they would. That's the reason if you look at our letter, we were very specific and clear in what we were linking. Mr. Rod Sanchez isn't just the building official under Chapter 10. He's also the administrator of Chapter 35. We referenced that for you in our letter. He's both. To sit around and to say that Mr. Sanchez can take off one hat and now Chapter 35 is no longer under his purview is disingenuous. He wears both hats. Both Chapter 35 and Chapter 10 are under his purview. I get the point that Mr. Shannon was making when he's arguing that what are we supposed to do about some arcane EPA regulation that Mr. Sanchez does not regulate. That's fair, and I want to be fair. But it's disingenuous to say that Mr. Sanchez does not regulate Chapter 35 and Chapter 10. Respectfully, it is disingenuous to claim that Mr. Sanchez and any of his delegable employees any employee to whom he delegates, does not have authority to cross-reference any of the city codes under their jurisdiction. They do. And in fact, Chapter 10 requires them to do that. It requires them that before they issue a permit, they must cross-reference that. And so, they would have you believe that that is meaningless language that the city council put in the code. Respectfully, it's not. It's also not a proper construction of law. Under proper construction of law, you give meaning to everything that a legislative body enacts. You don't say it's meaningless. And so if they put in Chapter 10 a cross-reference that they are required to look at all pertinent laws to ensure applicability and compliance, then they are supposed to do that. It has meaning. And if the city council put in Chapter 10, as they did, that the board, which is you, has jurisdiction to review whether a permit was proper or whether the interpretation of the code is proper as applied by Mr. Sanchez versus as applied by the appellant, then you do have that authority. And you have absolutely more than authority, you have an obligation. Respectfully, you have an obligation to look at some of the zoning matters that are implicated. As we talked about last time, the city is playing a shell game. Mr. Shannon informed you that there is pending litigation with another party, and that's fine. But as I told you in rebuttal, and the chair was kind to give me some minutes for rebuttal, and I thank you, Mr. Chairman, what he didn't tell you is that the city had taken the position that we shouldn't even be there too. So the city has set up a choice between a rock and a hard place to try to avoid their decisions from ever getting reviewed. And they are the gatekeeper for the boards that allow them to be reviewed. At some point, we might determine the constitutionality of that very interesting scheme. But the reality is, if you look at the plain language of what we have set out in our letter, you actually have authority to review the zoning matter. It is that simple. So, I would like to call Dr. Jose Santos to present some testimony.
Excuse me, sir.
Yes.
You through with your presentation?
I was going to, well, let me ask you this. Is the chair going to allow me to interview witnesses as part of my presentation?
It's not normally our procedure.
Is that a no?
Dr. Sanchez, did you sign up to speak and ask to be moved to the top of the list because you have patients to see?
Yes, sir.
You'll be given time during the public comment session.
Okay, then I would like to call Rod Sanchez so that I may cross-examine him. And Mr. Chairman, I handed the board what the city had handed me, and I will read what they identified as the procedures for this board. Quote, "This includes an evidentiary hearing with the right of the party to offer evidence, cross-examine adverse witnesses, inspect documents, have sworn testimony, and have written findings of fact supported by competent, substantial, and material evidence," end quote. So that's the reason why I was seeking to place some witnesses, and Mr. Sanchez is probably an adverse witness.
Mr. Chairman, have you ruled on this? The question?
No, I have not. I saw Mr. Murphy conferring to Mrs. Sanchez. I also see in the information you hand out, the last sentence, that it says formality of trial is not required of street adherence to evidentiary rules.
That's correct, Mr. Chairman. And to me, that means that hearsay can be admitted and hearsay within hearsay and things of that nature.
Mr. Drutter has presented an interesting thing in my time with the board. It's never actually, sorry, can you hear me?
Yes.
In my time with the board, it's never actually been asked whether or not it's been cross-examined. We think he can. It certainly is within your purview to authorize that if you wish.
I'll permit you to cross Mr. Sanchez in regards to actions regarding Chapter 10 only.
Mr. Sanchez, you're the Director of Development Services for the City of San Antonio, correct?
Correct.
And as Director of Development Services for the City of San Antonio, you are the building official responsible for the issuance of these permits, is that correct?
Correct.
But you did not personally review the issuance of these permits, correct?
No, I did not.
In fact, it would have been one of your employees that you delegated that authority, correct?
Correct.
And do you know, as you sit here, who that employee would have been?
I do not.
Now, when these permits were issued, they were issued under Chapter 10, isn't that correct?
That's correct.
And for the permits to be issued, an application had to have been filed, isn't that correct?
Correct.
And the applicant for the application would have had to identify the use and occupancy of the building, isn't that correct?
Correct.
And then you or your staff would have had to review the permits, isn't that correct? Correction. You or your staff would have had to review the application, correct?
We have if you file online, the system checks, so.
Is there ever a live person that looks at the permits? Or correction, is there ever a live person that looks at the applications for those permits?
An inspector does.
So an inspector would have had to look at the application for the permit, correct?
Correct.
And is the inspector the one that would make a determination of whether or not that application is compliant with all applicable laws and regulations?
An inspector goes out to check whatever's installed and ensure that it is in accordance with the code adopted.
Objection, non-responsive. Would that inspector have to go ahead and look at that particular application to ensure that it is compliant with all applicable laws and regulations under your purview?
As I answered before.
Okay, so is that a yes or a no, Mr. Sanchez?
It's the answer that I provided.
Is that a yes or a no?
We can do this all day. It's the answer I provided.
Okay, so they go out, so then let's ask it this way, Mr. Sanchez. Who reviews that application for permit to make a determination that it is applicable, that it is compliant with all applicable laws and regulations?
Our inspector goes out to make sure that it's...
Excuse me, objection overbroad. Ask what code you're talking about, please.
Mr. Sanchez? You are familiar with Chapter 10, is that correct?
Correct.
And you are familiar with the provisions of Chapter 10 requiring a review for compliance with all applicable laws and regulations, correct?
Correct.
And so my question, now we've established that predicate to satisfy Mr. Norbert Hart, my follow-on question is, who reviews that application to ensure that the provisions of Chapter 10 requiring that issuance of the permit is predicated upon compliance with all applicable laws and regulations? Who reviews that for that purpose?
Our department does.
And who in the department?
Various individuals.
And who would review whether or not that particular permit would be being issued for a
I'm sorry, repeat the question.
Yes, Mr. Sanchez. Who would be reviewing whether or not that particular permit was being compliant with Chapter 35? If you know.
We have folks that review the building permit for zoning. I'm not quite sure who does that.
Fair enough. But it's not you, correct?
I did not review this particular permit.
Okay. And as a general rule, you would not be reviewing permits. You yourself would not be reviewing permits for zoning compliance, correct?
I do not.
And so as you sit here today, you do not know who reviewed this particular permit for zoning compliance, correct?
I don't.
Now, part of a review for zoning compliance would be to ensure compliance with the zoning district use, correct?
Sorry, say that one more time.
Part of a review for a permit for zoning compliance would be to review the matter for a zoning use for compliance with the use for a designated zoning district, correct?
I do not understand the question.
When you're reviewing a permit for the use identified on the application for zoning purposes, you're looking also to see whether or not the proposed use would be compliant with the designated zoning district, correct?
Correct.
And if it is not compliant with the use matrix, then there would be a review for substantially material use, correct?
Correct.
Now, as a general rule, Mr. Sanchez, would you be reviewing that personally for substantial material use, or have you delegated that to staff?
As a general rule, staff reviews that.
And so, in this particular case, did you ever personally review the use of the property at 2140 Babcock for materially similar use?
I have.
Before or after the August permit?
Excuse me, just for clarification. Mr. Chairman, did you not talk about Chapter 10 being the limitation of our questioning and answering? Is that right?
Yes, I did.
So can you help us make a ruling if these are even within your instructions?
Mr. Chairman, if I may respond, the ruling was specifically limited to Chapter 10, and we've already established from Mr. Sanchez's party opponent admissions that as part of a Chapter 10 permit review, it does include a zoning review, and he as a general rule does not personally participate in that. So now we're trying to establish if he participated in this particular zoning review that would have led up to the issuance of these particular permits. It is directly related to Chapter 10 by his own admissions.
Mr. Sanchez, just answer that question.
Now, what was that? Sorry.
I thought I heard you respond to the question about did you personally review the zoning application?
I reviewed it after the fact, yes, I did.
Thank you. Now that that's been established, you can get back to the meat of the matter, reviewing the legitimacy of the issuance of new plumbing permits.
So, Mr. Sanchez, when...
Excuse me.
Yes, Mr. Chairman.
Let's get back on track and get directly to the two issues that are plumbing permits issued on Chapter 10. This is not a zoning case. There are no people on this board that are experts in the UDC or zoning. And as it's pointed out, that when a appeal is made, that someone on the board must be an expert in the subject matter. We have members of the board here that are experts in plumbing issues, and there's no one here expert on zoning issues, so we will not hear any more zoning discussions.
Mr. Chairman, are there any engineers right now present on the board?
Yes.
Who would that be? I'm trying to see. I don't see every tag on it.
Mr. Garcia is a mechanical engineer. Mr. Hunter at the end of the board is a plumbing contractor.
Understood. I respectfully submit to you, sir, that as a developmental engineer, they would, that person is actually an expert on the development that directly relates to zoning. Zoning matters actually require either with architects or engineers to help develop the zoning courses of action. So,
There's nothing in the International Mechanical Code or the International Plumbing Code that relates directly to zoning. That's a building issue. It's not under the purview of this board.
so Mr. Sanchez, is the identification on an electrical or a plumbing permit application for use or occupancy of the property meaningless?
No.
And in fact, it's safe to say that it has a meaning for Chapter 10, correct?
Yes.
Was there a question? I'm sorry.
It's not meaningless, correct? And it's being used on an application under Chapter 10, correct? Correct, Mr. Sanchez?
Under the building permit, yes.
Do you know, Mr. Sanchez, how a materially similar use was established for 2140 Babcock?
That's a zoning question.
Yes. Judge,
Do
you
you,
heard the chairman.
do you know, Mr. Sanchez?
I'm not answering.
Are you refusing to answer, Mr. Sanchez?
He's not answering on advice of counsel.
And who's his counsel, Mr. Hart?
Robert Hart.
Chairman, members of the board, at the last hearing, you heard Susan Gwynn come up here and explain how somebody established a materially similar use. We now know today from the testimony of Mr. Sanchez that it wasn't him, at least not at the pertinent time, for 2140 Babcock. Now that's contrary to court representations, but that's a different story for a different day. However, now that we know this, what Susan Gwynn tried to explain, she tried to explain to you the process for materially similar use. And she was showing you the zoning matrix, specifically table 311-2. Mr. Chairman, members of the board, if you would look at the screen, the use matrix is identifying.
Mr. Chairman, objection. What has this got to do with Chapter 10? This is a Chapter 35 zoning issue, and it's not in the purview of the board, as you clearly told Mr. Drillier that.
Mr. Chairman, I believe the chair's rulings were regarding the testimony of Mr. Sanchez. The board has already heard testimony on this in the past. I'd like to point something out to the board, and then I'm going to move on.
Let's move on right now. We heard this 2 weeks ago.
If you look at the letter made the basis of the appeal, it's specifically referencing LBCS, as does the use matrix. The use matrix in the column of LBCS contains the number, the code numbers of the property used for LBCS. And if you look to page 4 of our letter,
Sir, getting back to the zoning issue, please direct your questions or comments relative to Chapter 10, plumbing. Also, the basis of your appeal in your letter, you specifically say this is an appeal of electrical work. However, you're submitting 2 applications for plumbing work.
so we can consider that misnomer. I will just say this. If the board last time voted 7-5, there were 5 members on this board that believed that there was a zoning issue and that the board had jurisdiction to consider that. Right now, Mr. Hart and the chair are attempting to stop the board from independently considering its own jurisdiction on the vote that it will be taking on resolutions. I respectfully submit that that's improper. The board as a whole has a right to make up its own mind. 5 of you did last time. From what I could tell from the deliberations last time, at least 2 of you also believed that there was a zoning issue based upon what was presented, and that a materially similar use was improper, and that you also were concerned about it. 2 of you did not believe that you had jurisdiction. And I was going to try to sway you to that point, but the chair is trying to stop me. And that's unfortunate. But it's contained in the letter. It is contained in the letter what you can do with Chapter 10. It is contained in the letter the specific links that allow you to consider what was proper. You heard Mr. Sanchez say that it's not meaningless. The position the city had previously taken seemed to imply meaningless provisions are contained on an application. Mr. Sanchez has now testified that they're not. And if they're not meaningless and every word means what council intends them to mean, then it is very clear that before a permit can issue, it must be zoning compliant. And before a permit can issue, it must be reviewed. It must be reviewed for that compliance. And we have submitted in our letter a reason why that doesn't exist. On page 4, we quote the code. We quote the code on how Mr. Sanchez or someone in his department should have determined a materially similar use. And if you look at that example at the top of page 4, which is a quote from the code, it specifically tells you that just because something is in a category doesn't mean that it can go downward, or correction, go upward to a more general category. If it's express, it's express. And so what the city has done, despite what they've said, is improper. And so what we're going to urge you to please consider the argument contained in our letter and the example contained at the top of page 4. And we're going to ask you, please, do not fall for a disingenuous argument regarding what is meaningless, and do not fall for a disingenuous argument regarding your authority. 5 of you believed last time you had authority. I urge that 7 of you believe it this time, because the majority of the board last time seemed to indicate that you believe there was a zoning problem. And most people in this room know that there is. Thank you, Mr. Chairman.
We'll now hear from the citizens that signed up to be heard. Who wish to speak to the plumbing issue, as requested, let Dr. Jose Santos speak first. 3 minutes, sir.
Thank you for hearing my comments on this. The comments refer to what is considered a center for doing eye surgery versus carrying out abortions. And what their difference is, how much material do you create that is considered hazardous waste? We are being told that they are very similar, and such a consideration was made to make an exception. In one procedure, LASIK surgery, which I had once in my life, they carve the outer layer of your cornea off, and they laser zap, vaporize the material they want to remove. There is no hazardous waste. That same cornea gets flapped back right on like a Band-Aid. There is no stitches. The person takes a sedative by mouth and walks out of the procedure. On contrast, an abortion procedure requires preparation the day before to start expanding a closed opening. It starts with a suction device that looks like a caulking gun, and it creates suction in order to be able to pull out the baby and the birth products that are in there. You have to pop this little water balloon, and then through a sharp tool start scraping. Now, any woman knows that there's bleeding just from a natural period. Well, there's a lot of bleeding from this very vascular structure. This creates a lot of waste, a lot of bloody waste that now has to be treated like hazardous material. There is a big difference between being a very sterile and low residue surgical facility and now being a facility that creates bags and bags of material. Matter of fact, once you pull it out, you have to reassemble these 5 or 6 parts, a head, and you're required to check every part to make sure you didn't miss a retained birth product, as it's called, or it can cause very serious complications. So, big difference between a dry, vaporized procedure and a material that creates about as much matter as what you could fill a caulking gun under great suction. I ask you to consider this when you're being told that they're very similar and not much difference. Thank you very much.
Mr. Chairman, may I request that the speaker give his name and address for the record, please?
My name is Dr. Jose Alfredo Santos. I've been in practice in San Antonio as a licensed physician, licensed since 1985, and practiced in San Antonio since 1988.
Thank you. Before I call the next speaker, when you're called, you're asked to speak, we need to know your name, the company you represent, the organization you represent, and your home address. Next speaker is Mr. George Lejos.
George can't be here. He represents Moonlight, and he'll be here next week.
Pat Heil.
Mr. Chairman, members of the committee, my name is Dr. Pat Heil. I'm a resident in Dream Hill Estates, 6907 Dorothy Louise 78229. I'm here to object to the approval of the inspection at 2140 Badcock. I understand that your purview is plumbing, electrical, mechanical. What if you were to arrive at an inspection area and upon entering that area you realize that every time you turned around there was some violation of code, particularly code as it relates to zoning. I know that zoning is not your purview, I understand that. But if you arrived at a place that every time you turned around there was a code violation, it was improperly zoned, wouldn't you do something? Would you go ahead and inspect the plumbing when you knew that the entire structure is completely out of place? This structure is within feet of a residential area. It has been zoned C1. There is only one other surgical unit in San Antonio zoned C1. It was zoned that way. It was the laser facility they've alluded to. It was zoned that way because it was grandfathered in. There is only one similarity. There are two similarities between that laser unit and this surgical unit. They're both day surgery units. There's one other similarity. Both of them should not be classified as C1. But the first unit, the laser unit, was grandfathered in. I can understand that. Let's not make the same mistake again twice. There are 100 reasons why this is not zoned properly. When you show up for a plumbing inspection and you realize that everything is out of code, something needs to be done. And that's what we're asking you today, to do something about this that is so far out of code. There's only one similarity between the laser unit and this day surgery unit. There are 1,000 other reasons why they are completely dissimilar. Please consider this as a decision that's within your purview to make. We ask you to reject the inspection, or at least to make the decision of no decision until the case is decided in court. Thank you.
Morning. My name is Melissa Quante, and I reside at 4802 Betty Lou Drive in Dream Hill Estates. I came here today to oppose the approval of this inspection of 2140 Babcock. Dream Hill Estates is a beautiful neighborhood that has a wide range of ages of residents. Many are here, many cannot be here because many are very elderly. I found this following quote in the My SA publication that was dated April 3rd, 2015. This quote is regarding 2140 Babcock. The exact quote is, "The folks that are really upset about this," meaning that area, "don't live anywhere near Dream Hill Estates." That's a direct quote by City Councilman Ron Nirenberg. Well, look behind you. We are upset. Building of this facility will not only destroy the tranquility of our neighborhood, it will decrease our property values and endanger our very safety. Delivery trucks and clientele driving through the neighborhood will drive through our neighborhood because it's a very easy shortcut to get to the facility. Recently, a water pipe burst directly in front of our house. It took them probably a month to complete the work. We couldn't even get into our driveway. And the work crew said it was because our pipes are closer to the street and because of the heavy traffic of UPS and even mail trucks that pipe burst. And now we're having very many heavy delivery trucks take a shortcut through right in front of my house to deliver to that facility. I also want to tell you that it scares me for our entire neighborhood because it has been very well documented that there's often violence, drug deals, prostitution deals occurring in the parking lots of such structures. And that has been very well documented that there's an increase in violence. We want to keep our neighborhood safe, tranquil, and keep our property values high and not use our very own property taxes to help fund this project. Thank you.
Laurie Rios.
Hi, my name is Lori Rojas, and I'm a resident of Dream Hills Estates, and I appreciate you guys so much. I thank you for coming because it really helps me feel like I'm getting my due process. This is my day in court, so thank you for hearing me out. But I'm here today to oppose the approval of the inspection of 2140 Babcock. I oppose any of the permitting that goes on. In terms of the plumbing of the building, you're retrofitting an old building. The building's over 30 years old, and it's in a neighborhood that's over 100 years old. So many of our neighbors had septic systems, and several still do. So when you start adding in a regional headquarters of a national brand, they will have a very high use. So we can expect more water main breaks. That water main broke February 23rd. Mrs. Quante lives just 2 houses down from me. We had water gushing down our street. SAS came out and told her, expect it again. Keep the commercial trucks coming through. Your streets, you do not have the infrastructure set up to handle heavy traffic. So when we talk about approving a permit for a natural gas or for a water heater, you can expect that we will have problems. If we have a blowout on the side of the building, we have homes that back right up to it. Driving over here today, a home that is adjacent to 2140 Babcock, of which they're working in today. They currently work there. They don't need a certificate of occupancy for whatever reason, because they work over there. But the home that backs up looks like a bayou. It's got water standing there. Since the Planned Parenthood has started construction, they've had so many water breaks. They've had numerous. It's at least 3 water breaks right on the property that backs up to 2140. So we can anticipate that this will continue. Right now, in the back of my yard, I back up to a restaurant where there's a grease trap. I would assume that this building also needs a grease trap because, as the doctor testified earlier, you're talking a lot of human waste. So if the restaurant needs a grease trap, so do these guys, and grease traps smell. Grease traps present a huge problem when you're talking about the summer heat, the wildlife that's occurring. So if they need a grease trap, that's going to trigger an inspection. I would dare to guess that this permit should not go through until SAS and the city have done an impact study on the water lines that are in our neighborhood. Our streets aren't that wide. It's probably not that deep. I've asked several times recently for SAS to check the manhole that's in front of my house because it stinks. So I don't know if the cap's not on right or we're expecting a problem to come. Excuse me. So what I would encourage you to do is to reject this permit until there's been further investigation. Thank you very much.
Ms. Thelma Franco.
Yes, hello, my name is Thelma Franco and I'm a resident in the Dream Hill Estates on 7115 Beverly, Maine. And I'm here to oppose the inspection, the approval of the plumbing. As my other residents have spoken to you before already, our concern is that we heard that the plumbing original permits were only pulled for a gas opening and a water heater. Now, if this facility is going to have so much waste, which we don't want in our neighborhood, there was nothing said that there was a permit pulled for a waste trap. I wonder why. If this facility is going to open and it's going to have all this waste, medical waste, which we've seen nothing there for that already, I'm asking why. If we're here about a plumbing permit and about the plumbing, why has there been nothing mentioned about a waste trap permit pull, or even an inspection, or even see that this building facility has a waste trap? What are they going to do with all this waste? The plumbing, we're already talking about the water, the lines that are breaking in our neighborhood already. What is going to happen when they have all this waste? What are they going to do with it? Right now they have the tiny little bitty dumpster in the back. It's not even big enough for the facility. What are they going to do with all this waste? Surely they don't want to keep it inside their building to smell up the building. Are they going to put it outside so that our neighborhood has to deal with it? You know, I would ask that the board would check into this plumbing permits and see why a waste trap is not put in, because if it was, the only thing that the permits will pull for was for a gas opening. Surely that can't be for waste, and then a water heater. If those have already been inspected and approved, I ask the question, if the plumbers have gone and done this and they know what kind of facility this is, why hasn't anybody asked, what about the waste trap? If they're going to call this a surgical center, surely that goes under plumbing, under permits, whatever it goes, but it has to go under somewhere. And we haven't heard nothing about that today. You know, I thank you all for hearing us, for being here today, but I do ask that you raise the question yourselves. What about the waste trap? If this is about plumbing permits today, then let's ask about where's the waste trap. Thank you for your question.
Danny Heaton.
Board. My name is Danny Petrie. I'm a CPA here in town, but I live on 129 Rilla Vista. I've been down here before for a board hearing. I'm here to talk about the 2140 Babcock, and the issue that I don't think y'all see is that if we start at the math equation, we all have math equations. If you start at the very top and there's something wrong with it, you're not going to get the right answer down at the bottom. You can't get the right answer down at the bottom because it was wrong at the beginning. Because that's where this is. The zoning is incorrect. That's at the very top. So the permit that you are going to approve cannot be correct because it was not correct at the top. You have that authority to do that. When you see something that's wrong at the bottom because it started at the top, how can you approve that? How can you say, this is a square hole, so we're going to make it a triangle? Okay, that doesn't make any sense. You have the authority to do this. The permits that are at issue here, okay, are not correct because they do not address a commercial C3 building. If they did, then I ask you this question. Is a commercial 3 zoning requirements, okay, for plumbing the same as a residential house? The answer is no. I've built onto my house. I've been through this process with the city. The permitting is not the same. Y'all sit here, each one of you have an obligation to these citizens because they were never heard initially. They were not given their due process. The director over there did not give them the due process to speak up and say this is wrong at the very beginning. And so y'all stand here, y'all sit here, and y'all have the opportunity to say, no, you know what? At the bottom of this equation, it's wrong. And we have something, we should be able to do something about it. Thank you for your time.
Mr. Philip Trickett.
Good morning. Thank you for the opportunity to speak. My name is Philip Trickett. I'm a retired Lieutenant Colonel in the United States Air Force. I've spent 41 years defending the freedoms that we enjoy having you as a member of the United States of America in the check and balance system against our government, the exact way our Constitution was set up. You are a check and balance to make sure that things are properly done by the businesses that want to erect things in our city and to conduct business. You check and make sure it's safe. Am I right? You have expertise in that area. Not only that, you check whether or not our government is doing things right. For testimony, there's something not right about what has gone on so far. I ask you to fulfill the obligations that your citizens expect of you. And not only that, our Christian aspects expect you to do what's right in this area. Thank you.
Sylvia Villarreal.
Good morning. My name is Sylvia Villarreal, and I'm a resident of Bexar County, San Antonio, Texas. And the reason that I am here this morning is because first of all, I just want to say that the city's behavior this morning is enough to tell you that they are trying to paint a picture that oil and water don't mix. Chapter 10 and chapter 35 don't mix. Well, I'm here to tell you that it is not oil and water. This is blood and water. From the get-go, we were the first responders at City Council about zoning. And of course, we're not here to talk about that, and you don't want to hear about that. But I am telling you that from the get-go, if the zoning is wrong, how can anybody proceed with all of these permits? So if the city is so apprehensive to tell us that this is not mixing here, then you need to pay very close attention. Now I think you've all become aware that this is a bigger animal than you anticipated, and it is. Planned Parenthood is a business for profit, and this is big business. So they're about to gag and mute anybody that gets in their way. And this has been very evident this morning just by the behavior of you all leaving the room with the city attorney, which I think is very controversial. This gives us a very ugly picture of our city leaders and my money at work and all this non-transparency that we speak of. So please, I say that you make a decision to not make a decision this morning until this is all cleared up in a court of law, because something is pending. So I ask you to make no decision this morning. Thank you.
Jack Finger.
Mr. Chairman, other members of this board panel, my name is Jack M. Finger. You're saying that you're dealing with plumbing issues, it's not a zoning issue. I'm telling you that your arguments are based on a house of cards. Standards are different between a C1, C2, and C3 for plumbing. It's been, last time it was compared to lazy eye surgery, abortion. I'm sorry, with lazy eye surgery, you are not disposing of major body parts. I dare say, do any of y'all really know what an abortion really truly looks like? This is what's going to be happening at this facility. It's what you're going to be ruling upon. This is a picture of an aborted baby. It's what happens at abortion clinics. It will happen at Planned Parenthood clinics. This is day surgery. Folks, in a surgery, abortion, the surgeon or the surgeon's assistant has to chop up the legs, the arms, and it has to pop the head off of the torso. Yes, and then that's inside the womb, and then they have to pull these parts out, reassemble them to make sure that no infection occurs. And sometimes the head gets lost in there because it rolls around. Folks, you wouldn't do this to a dog. And yet Planned Parenthood is going to do this 11 times a day. 11 times a day. Now, you think that's not going to clog up some pipe somewhere? I'm sorry. I think all of y'all know what the right decision is to make on this. But you're probably wondering, well, how am I going to face my colleagues, my superiors, the people who appoint me to this? I'm telling you, you can make the right decision right here and now. And just tell them that, just look in the eye of fate and spit in it. This is your finest hour. You can make the decision that says, this is wrong. Just by mere plumbing, this little decision right here, it will have major ramifications because you did the right thing in saying this is very inconsistent with the laws, with the code, with the rules. You can do this. Thank you.
Marion Thompson.
My name is Marion Thompson. I'm a resident of Bexar County at 2823 Old Field Drive. I am here for various reasons. First of all, y'all have heard the homeowners explain why this is going contrary to the wishes of their community, a 100-year-old community which isn't prepared to handle the type of plumbing and traffic that's going to be going on there. Plumbing hasn't been mentioned. This was commented on, the waste traps. We've also got another issue about money. And I'm always appalled whenever I see things revolving and issues going circumventing around what money is. Well, the fact of the matter is that $100,000 has been donated by Planned Parenthood and the top 50 Planned Parenthood donors to people on the city council who are running for re-election for their campaign funding situations. That is abhorrent. And to say that this is not relevant, whether it's a C1, C2, or C3 issue, is another thing that's abhorrent to me. I am a believer in Jesus Christ. Jesus Christ in the scriptures constantly goes after one thing, and that is justice. You people today are going to be responsible as to whether or not justice is performed. You do not need to make a decision today until you have all the facts. Contrary to even some of the House rules that this gentleman pointed out a while ago, that everything seems to be stacked against us, the people that are trying to do what's right. You people have a responsibility to do what is right. You know, any nation that is considered to be great in the history of the world has been determined according to God in Deuteronomy 28 and 29. And here's what the Bible teaches. Any nation that does not honor Almighty God as the true and living God, that nation is going to be cursed. Any nation that does honor God as the true and living God is going to be blessed. When we honored God, we were blessed. When we have begun to start dishonoring God, and there's two abominations mentioned in the Bible. One abomination is the shedding of innocent blood. That's really the issue that's here today, ladies and gentlemen. It's not about all this zoning garbage and everything else that y'all are responsible for. The shedding of innocent blood is an abomination to God. The other abomination is homosexual lifestyles. A man should not lie with another man like he lies with a woman. Those are the two abominable acts according to the Bible. Now we have in our city of San Antonio, and I cherish the city of San Antonio, but I have seen decadence and immorality start creeping into this community. When you have the chief of police as the grand marshal for the gay pride parade, that is, I went and spoke at the city council about that because that was abhorrent, and yet that's what we've done. We also have condoms that are being passed out in city clinics. That is abhorrent to the rules and regulations in the Bible and the scriptures. We also have what was another one that was really horrific? Oh yeah, a law was passed that men who, because they're transvestites, can go into ladies' restrooms. Ladies and gentlemen, since when does a woman have a right?
Your time is over, sir.
And just remember, no matter what happens, God is still in control. We will emerge victoriously in the end, and Jesus Christ is our only hope.
John Cope.
My name is John Cope. I live in Kings Ranch Forest here in San Antonio. I think Mr. Rutmore, I think maybe your dad or somebody developed that subdivision there, so thanks. We appreciate it. It's a great place to live. It's not quite like Green Hill Estates where you have as big of lots, but it is a small community. We've only got 70 homes in there. I'm a real estate broker, have been for over 35 years. And the thing that I'm concerned with is that there be integrity on our boards, that there be consistency in the zoning laws. You all as contractors and engineers, you all know that's very important, that you can put confidence in that the zoning laws will apply consistently to everybody, not because you got more money that's being paid under a table, but because that your officials will adhere to the laws that they've passed, and everybody will have to abide by the same things. We've had in our neighborhood someone that wanted a simple thing like a fence to be 6 foot high instead of 4 foot high in the front yard. And they sent out notices to all of the neighbors to let us know that someone was asking for a variance for this fence. And they also posted a sign, those little yellow signs you see all over town saying that there's a zoning change here. That was never done in Dream Hill Estates. These residents never had an opportunity to voice their opposition to what was going on. The Planned Parenthood facility on the permit, the construction permit, did not put Planned Parenthood. They put Del Antero Limited. Del Antero, which means front. Do you get the significance of that? They weren't allowed an opportunity to voice their opposition. That's wrong. They should be treated equally, the same way that I was, just for a little 6 foot fence versus a 4 foot fence. I was given the opportunity to oppose that, and we did, and that 6 foot fence didn't go up. but a much more serious issue is going on at Dreamville Estates. They should be afforded the opportunity. Why are we here before you, engineers, plumbers, electricians? We're here because you're the closest thing they have to a representative in city government. City attorneys, Mr. Sanchez, people that work for the city, they get their livelihood and their paycheck from the city. They can't be counted on to represent citizens the way that a citizen board can. Do the right thing.
Rosemary Glass.
My name is Rosemary Glass, 10943 Falling Water. My husband is a colonel in the Air Force. He has been in for 35 years. San Antonio is my home, and I've moved here 5 different times. And he's the number 3 in command at Wilford Hall. He was instrumental in the Ebola outbreak and what the government had asked the military how to handle that. That was very important. He has to follow numerous rules and regulations working at this hospital, and because it's the military and the government, there's infinitely more rules. My question for this board is, why don't you have to follow the rules?
Ramon Rodriguez.
Ramon Rodriguez, 603 Southwest 39th Street. What I have noticed today and in other hearings is our process for the citizens is totally broken. Citizens don't have a chance coming up here and pleading the case. So that's mainly what I'm saying. Process is gone.
Betty Eckert.
My name is Betty Ecker. I live at 233 West Wildwood in Almost Park Terrace. I find this appalling that this group has to come here, that citizens have to come here and speak before this board. The Board of Adjustments should have heard this board. The Zoning Commission should have heard this board. But instead, we have plumbers and electricians hearing the board, hearing us today. I'm going to ask you to do the same thing that Ms. Vivial asked you to do. Wait until you have all the facts. Do not make a decision today. You can't make a decision today because you don't know the facts. Remember that we do have citizens that do care about San Antonio, and I'm hoping that this board cares about San Antonio also, regardless of what position you're sitting on, or what board you're sitting on, or who you know, or why you know, or what business you're handling. I'm asking you again, make no decision when you don't have all the facts. Thank you very much.
Patrick Von Dolan.
I find it interesting. Good morning. Appreciate you taking time to hear us. I would ask the chairman to restart my time so that I'm able to present this. However, What I'm showing you here is that, as Mrs. Eckert just said, by the way, my name is Patrick Von Doe, 2811 Redwood Creek, and I represent the San Antonio Family Association and concerned citizens, concerned residents of Dream Hill Estates. Mrs. Eckert just alluded to some of the speakers before. Each of you know what a chain of command is. Each of you know that our children can help us do the right thing sometimes. And in this case, you are the children compared to Rod Sanchez at the Board of Adjustments. Will the children stand up and let their parents know that something's not right? My children will. They point it out to me every day. Matter of fact, when we're doing an examination of conscience, said, Dad, you're doing that an awful lot. You need to stop. So I encourage you that you would be the dutiful children here and do your responsibility and tell your parents, Rod Sanchez and crew, that this is not moral to put you in a rock and a hard place and relegate this. So what I've given you is an ordinance that was passed January 29th. It's the building-related codes of the city of San Antonio, chapter 10. This is what I wanted to talk about. And so turn to page 2 of 990. There are alterations that are shown in underlined text and deletions that are shown in brackets. So turn the next 2 pages. On page 11, paragraph H says Board of Appeals. Amy, if you'll put this up please. It says Board of Appeals action was taken. Any action taken by the building-related and fire codes boards of appeals is final. Well, that's new as of January 29th this year. Isn't that coincidental? This year is the year you're taking, we're being put before you instead of the Board of Adjustments. We keep being denied by Rod Sanchez and crew to go before the Board of Adjustments. We can't get there because we're being denied, which is where the lawsuit's coming out. You're being relegated here. You are the people being put between a rock and a hard place. I feel for you. I feel sorry for you. But this was changed on January 29th of this year. What was stricken out was may be appealed by a written petition for a hearing before the mayor and city council. The citizens are out of due process again. Not only Dream Hill Estates residents, but now all of us, by your decision making. And your decision making is final. So this says now, as of January 29th. Well, turn to the last page if you would. Anybody know what council district 2140 Babcock is in? It's in District 8. Anybody know who the city councilman is for District 8? Ron Nurnberg. Anybody who knows who's received over $7,500 in contributions from the top 50 donors of Planned Parenthood? Rod Nurnberg. Anybody know who presented this motion? Ron Nurnberg. You're in a rock and a hard place. Make the right choice. Tell the parents to do the right thing. Say no.
Mike Kufke.
Thank you, Mr. Chairman. It's Mike Knufke. I'm at 45 Northeast Loop 410. What I have up here on the screen here shortly is the map. Let's start on the right side. The right side of the map here is an aerial of 2140 Babcock. And as you can see, it is extremely busy. There's no traffic lights. The only legal way to get into the facility is coming south on Babcock. If you're having to be coming north on Babcock from 410, you're going to probably end up either turning into the Dream Hill Estates residence that they're describing here, or you're going to do an illegal U-turn and go into 2140 Babcock. What I'd like you to do is to hone in on, there you go, all those residents. Do you see those residents? They're will be killing babies within 30 feet. I hope you're hearing this. 30 feet of the sanctity of somebody's home. Judge Cassidy said in court, I can't blame you guys. Nobody wants abortion in their neighborhood. That's what's going on here. Like it or not, it's in your court. We're not here by choice. You didn't pick us by choice, Mr. Chairman. This table over here pushed us here. They pushed you here. Go to the right side there. The other abortion facility that's taking place is at John Smith Road. John Smith Road. We're not standing over there. We're not opposing that one. Why aren't we opposing that one? See the dot? Just put your finger there. There you go. The reason is, do you see any residents there? It's zone C2, more appropriate. It probably should be C3, but there are no residents. That is not the case at 2140 Babcock. Under section 10.6K, let me read it. The building official shall determine or cause to be examined the application for permits in order to verify compliance with any applicable laws and ordinances under their jurisdiction. But you're arrogant. Mr. Shannon, 10. I'm doing 10. If the application or the construction documents do not conform to the requirements of the pertinent laws, the building official shall reject such an application. Mr. Chairman, that's 10-6K. Once the building official is satisfied with that, the proposed work conforms to the requirements of this chapter, it can be approved.
Thank you guys for seeing me today. My name is Weston Martinez. I want to identify those of you that I'm personally friends with because I don't want anybody to haze you later. But I'm real estate commissioner for the state of Texas, and I was contacted by some of the folks involved in the situation, and I appreciate your time that you spend not only on this issue but other very important issues. And one of the important things that I would like to mention, as I looked at the information, as I saw what was going on, I had to take time to come down here because I am also a resident of San Antonio, 1123 Tranquil Trail for the record. And, you know, in our purview, just like the board of directors, you know, we have subcommittees that work for us. We have the professional inspectors, and I understand how these subcommittees work. And as a subcommittee, you shouldn't answer for dereliction of duty on behalf of somebody else. We just had a very passionate issue talking about corrugated steel and its potential deadly situations caused when it's cracked by nearby lightning. And so there's a very big group across the state that wants to outlaw corrugated steel when you're installing your furnaces and your different sorts of plumbing. So I understand how some of these issues can come up. But HB 2 was created to increase women's health during abortions and not to lump them in with other procedures. Texas law, as you know, gives anybody standing that's a taxpayer to bring the issue. And I would tell you, and I would also share with the director, that from a state level, everybody in Austin is watching how San Antonio is handling this situation, because the desire to increase women's health by HB 2, apparently there are ways for that not to go as planned without throwing any stones. So we are taking an advanced look of how we can update the Texas law so that it can't be thwarted by the local level. Now, I'm a conservative Republican, and I believe in local control, and I would encourage us as citizens of San Antonio to push through the local control and do something as simple as maybe adding abortion facility to the UDC. I looked through the matrix, it's not there. It's kind of, you know, we've got specifications for other specific issues. I think this should be one of them. In the process of this, I also reached out to a doctor that's a friend of mine that performs surgeries related to the eye, and I just want to read briefly what the response was, and then I'll finish my time. LASIK refractive procedures can be done in a physician's office, and ASC is not a requirement. The potential complications from LASIK refractive surgery are very limited and are associated with the cornea. The only bleeding complication may be limbal bleeding, which is controlled and stopped with gentle pressure to the oozing, she wrote very technical, to the oozing vessel. There is no significant blood loss during the LASIK procedure, thus need for blood transfusion from blood loss and unheard of following a LASIK procedure, anesthesia required for LASIK procedures, and a whole bunch of other things are not there. In stark contrast, she says, in stark contrast to LASIK, therapeutic abortions are riddled with life-threatening complications such as intrauterine bleeding, bowel and bladder complications, cervical laceration, and the list goes on and on and on. So in my time, I would just like to say thank you for your service. Again, send this back to the people that are responsible for this and that have given you your charge. You guys have served your city well in this position. It's not your call to make. Send it back over. God bless you.
Did you say? Elaine Hawkins.
Elaine Hawkins. I live at 19 Grass Market, which is Rose Heart on Wilberty Road. I'm a resident here of San Antonio, love it here. My husband was in the Army for 32 years as a pilot, and we traveled all over the world, but we met and married here at Fort Sam, so we just were real clear about wanting to come back here and retire someday. And I love this city. I'm proud of so much of this city, absolutely. And I have 3 children and 10 grandchildren and 2 great-grandchildren, all here. So I am busy keeping up with everything going on. In the 80s, I don't know what happened to me. I happened to be listening. I happened to be listening to a car radio one day in the mid-80s, and I heard, this is when Operation Rescue started, and I heard these people describing that you have to have larger plumbing facilities to go into Planned Parenthood because of the disposal of the little babies that were needed to take care of that. But they don't allow that in veterinarians places. You can't do that to a little puppy, but you can do it to human beings. And when I heard that, my whole life changed. I was busy raising 3 children, perfectly happy. I'm a Christian, I love the Lord, I want to obey the laws, I want to be a good citizen and an asset to San Antonio. But when I heard that on the radio, something inside of me just said, what? Women kill their babies on purpose? I can't imagine such a thing. What? Our laws say that's okay? Years ago, what did women do to go to the lengths to save their babies? They still now will give their lives for their children. We will. But to purposely, no, God allowed this little baby to be created, and they on purpose, for whatever reason, can go to a Planned Parenthood or go somewhere and kill the little potential, the life that was given. This is something that I am not proud of San Antonio to open up a big mega killing center in this city. I love this city. And I just want to say, if this is a question of rules and regulations and zoning going with the worst thing that could be going on, why are we here? Why aren't we doing what the right thing is? And if the right thing is not to open this facility for whatever reason, please stand by that. Obey your rules. You're given clear guidelines of what to do. So I just thank you for listening.
Sorry, I can't read the last name. It starts with an M.
I'm Bobby Miller. The German spelling is Mueller, I guess. I live at 8058 Broadway, and in a condominium of 104 residents. I'm on the board there, and our property is like 55, 60 years old. And no, it's more like, yeah, I think that's right. But we have terrible plumbing problems, and I can just imagine a 100-year-old property must be double that. But I did a study of our plumbing problems because there were questions on the board about why we were having such problems. And the amount of files on plumbing on that property was just heavy, a large stack. So I can just imagine the potential problems they were going to be having in the old age property where these people are living. I have a heart for babies, and I'm ashamed that San Antonio would be providing a place for this kind of center. And I'm here to hold you accountable. That's what my business card says. It's justice for all. And to hold our officials accountable. And I want to know who sits on this board and what kind of decision each one of you are making today. And thank you for your time.
David Biorga.
My name is David Biorga, and I'm a resident of actually District 7, 2511 West Gramercy. That's Jefferson area, not too far away from Dream Hills Estates. I'm going to be reading from a statement that the Archbishop made, and he made the statement on March 2nd, 2015. As a people of faith and as Americans, we are called to be a voice for the unborn who cannot speak for themselves. Any law that allows the killing of unborn children has no place in our society. I join my voice with Pope Francis as he rightfully proclaimed, "In the light of faith and of right reason, human life is always sacred." I am deeply troubled by Planned Parenthood's San Antonio Abortion Center, the largest abortion facility in South Texas. This great city, named for St. Anthony, built upon the legacy of the old Spanish missions and nourished by the faith of her people, must not become known as the abortion center of South Texas. This would be a betrayal of the values that built San Antonio. I strongly encourage our city leaders to only make exceptions and exemptions in implementing and interpreting our laws in ways that will strengthen our support for the dignity of all human life and the common good. It is your responsibility to preserve the fundamental liberties that define us, the first of these being the right to life. Thank you.
George Alejos.
Ladies and gentlemen, my name is George Alejos. I live in District 6, 9811 Ramblin' River Drive. I'm here today because LULAC is looking at this very closely. Most of my colleagues are right now in Lubbock attending the state convention, and my colleague and mentor, Henry Rodriguez, asked me to stay behind and come to this meeting this morning to make sure that I brief him when he gets back. Now, LULAC is looking at this because we believe that the killing of babies is something we should not be allowing. Butchering a baby is not the same as providing ambulatory and surgical services. Believe me, it's not. It should not be categorized that way. And in our opinion, that building at 2140 Babcock is nothing more than a monument to man's stupidity. Has no place in this city. The people are here, they've spoken. It's your job to make sure that the appeals are denied. People need to realize that they must come into compliance in order to do business here in San Antonio. And when you allow people, owners of buildings like the 2140 Babcock building, to proceed without, being compliant, that is very egregious. And the fact that Mr. Nuremberg received money from those people is also a very egregious thing, in my opinion. I would ask that you as a board look at this very closely and deny the appeal, because we need to make sure that these people are in compliance. Now, the intended use of this building switched somewhere along the lines. They switched it from where it was intended to be used to not to be used for abortion. And that, in my opinion, is not something that we should allow. So I would ask for you to do your jobs, and that is to deny the appeal. And let's make sure that everybody is in compliance whenever ordinances or issues like this come before you. Thank you.
Dave McCall.
Thank you. My name is Dave McCall. I work 2 blocks down from this facility. I want to thank each one of you for doing your jobs. I want to thank you for hearing the citizens. I want to thank you for hopefully not taking the bribes and for the money that was given to City Council. I believe every City Council person accepted money from this institution, or from this Planned Parenthood, with the exception of one. I have a question for you. I like to ask questions. Are you awake? All of you, Mr. Troy? Good to see you again. Why have you been selected to be on this bench, on this board? How did it come about? Why did the citizens even need you? Why did this city have this board? To regulate, to make sure, just as lots of these citizens have already brought up, that things were done appropriately, that things were done with character and with integrity. Obviously, most of our city council does not have character and integrity. They've taken money. We can argue that till the cows come home. That's a fact. So I ask you, raise your hands. Do you believe, if your children were standing here, your grandchildren, would you say that these people right here before us, men and women, are you a man or a woman of integrity, of character? Yes or no? Raise your hand if you are. Wards, are you going to raise your hand? Are you a man or woman of integrity? Thank you, Mr. Torrey is. Anyone else? Mr. Hunter, Mr. Elmore, are you a man or woman of integrity? Yes or no? Well, take the record. We got videos going. Most of you can't even raise your hand.
Sir, this is not an appropriate thing for you to be asking us to raise our hand when we have integrity, because every person on this committee has integrity, and that's not a fair...
Thank you, Mr. Hanley. Thank you. I would hope to agree with you. Absolutely. So therefore, what are you going to do? What has been done to this point is not of integrity. Mr. Hanley, thank you very much. Thank you. I mean that in all sincerity. He has said that you are. So be what you are. We can all tell our kids, we can all do this, and our grandkids, and say nice things, but way more is caught than taught. And believe me, there will be a day when your children will ask, weren't you on that board? Weren't you on that board that could have said, let's wait and let due process happen? Thank you so much for serving. I mean that. Thank you, Mr. Hanley, for agreeing with me that you're to be men and women of integrity. Take a stand. Do what's right. Thank you.
My name is Brad Wheeler. I am a resident of San Antonio. I live at 4002 Calle de Cobra. It's in the Presidio. And I just want to talk about one issue. Why you are sitting here and hearing this argument. Why this is before you. I want to also thank you for hearing it. You don't have to be on a board like this. You don't have to do things like this. Thank y'all very much. I appreciate it. But you're here because this is where the city has sent this group to be heard. You're here because 10-6K says that y'all are to hear any applicable laws. And it would be ridiculous to say that any doesn't mean any within the same code, within the same body of laws relating to buildings. In fact, specifically, the code tells us that words not specifically defined have their common usage meaning. So the code here says any. So it has its common use meaning. And I wanted to make sure I understand what any means, because we live in a day and time when words like is sometimes require defining. So I went ahead and I looked up any in Merriam-Webster dictionary. And it says one or some indiscriminately of whatever kind, one or another taken at random, such as ask any man you meet. Or it can mean every, used to indicate one selected without restriction. Any child would know that. 2, one, some, or all, indiscriminately of whatever quantity. Example, you have one or more, used to indicate an undetermined number or amount. Or, here you go, all, used to indicate a maximum or whole. You're to consider any of the pertinent laws. What does the word pertinent mean? I looked it up too, just because I want to make sure. Pertinent is having a clear, decisive relevance to the matter in hand. Whether or not this building is zoned properly is eminently relevant to the matter at hand. You cannot believe that you're simply to rubber stamp every permit that comes through for a building that is illegally being used for an illegal purpose according to the zoning laws. That makes you accomplices to what is illegally taking place. If you continue, the code gives you the authority in 10.6K to say the laws aren't right, therefore we cannot let this permit stand. I ask you to hear our appeal. I ask you to say that these permits do not stand. I ask you to decide, because you have been empowered, contrary to what city attorneys told you, you have been empowered, and it is in the code. You have the right to hear this, and you have the right to decide. Thank you.
Mr. Shannon?
Thank you, Mr. Chairman, and members of the board. I know it's been a long morning, but please bear with us, and thank you to everyone who showed up and spoke on this important matter. So, as I spoke earlier, this is a very simple plumbing permit, two of them actually. As I stated at the meeting last time, a couple weeks back, it's a very complex issue, it seems like, right? However, it's very simple, what we're trying to do here today. The applicants have actually appealed the plumbing permit. We've talked about how the plumbing permits get issued, what we do when we verify plumbing permits. But then the applicants and Mr. Drouillard and his colleagues and others here, they've chosen to make it complex. And by doing so, I'll just kind of just summarize some of the things they said, and at the end I'll make one statement of what they haven't done yet. Is they talked about the rules and procedures that you all use, that we use in our everyday meetings, not every day, but enough that we have rules and procedures. He thinks we should change them, housekeeping rules and procedures. Okay, well that has nothing to do with the plumbing permit, but there was some good advice from Mr. Drouillard. Maybe we'll look at that in terms of our board procedures, policies, who goes first, who goes last, type of thing. We can certainly look at that. He certainly implied again, as he did last time, that our city attorney is doing something unethical and possibly against the attorney state law, which I'm not sure you guys are going to judge that, but certainly that's his implication, although he did say he didn't know if there was anything wrong with what's happening in terms of who's representing who, but he certainly implied that. That was interesting. He made a lot of comments, or they made a lot of comments, Mr. Drouillard in particular, that there's a shell game that the city's going on. I would actually argue that the shell game, or the confusion that's being created, is done by those that just argued for a long time on a lot of different issues. Not one of them had to do with the water heater or the gas installation or those two permits that they asked us to consider today. They asked you to consider today with their application. They specifically chose these two permits for you to consider because they believe they're illegal. But not once did I hear water heater, gas, those type of things. With the exception of one woman who did mention, because she was asking about other permits, I think that question was more from Mr. Drouillard and why he's not asking, and his applicants are not asking about other plumbing permits, because certainly there are other plumbing permits. I think I answered the question from maybe Mr. Garcia on that earlier. So that shell game or confusion issue that there is down here on the city side, but clearly they spent a lot of time talking about everything but the issue at hand. We did get a surgery lesson, which was interesting. It was all over my head in terms of surgical stuff, so I appreciate the doctor being here. There were many comments about everything is out of code. Everything in the whole world is out of code with this project. We've had numerous individuals. We have in the City of San Antonio Development Services Department almost 400 individuals that review plans and permits, do inspections. They're certified, licensed, trained, those type of things, with all varying degrees of education experience to do this. And the City of San Antonio has deemed that this project is in compliance with it. So clearly, those outlandish statements about everything is out of code is to confuse us. Again, there was that question about other permits and why they're not being discussed today. Well, no one's asked us to discuss the other permits. That's what they asked us to do. They asked about, and made one of the the persons that got up and spoke was talking about, don't make a decision. Don't make a decision today. You guys don't have all the facts. I beg to differ. But don't make a decision because there's something pending in a court of law, which is where the zoning issue is being argued. Right? So they've asked us to don't make a decision because this is not good due process. The city has sent you there. There is another process to argue the zoning, and that's what they're doing. So again, a lot of that confusion, and I think they say things that are actually making our case. So I'm not really sure about that.
Mr. Chairman, point of
There
information.
were several questions. I'm sorry.
I'm raising to a point of information to the chair.
Yes, sir.
Sir, I'm sorry, I'm confused. Is the attorney giving y'all direction or just doing a play-by-play?
I'm not the attorney.
Great.
I'm rebutting testimony.
Great, thank you. I didn't know who you were. Thank you.
Okay, thank you. If I didn't already, I'm sorry. Mike Shannon, Assistant Director of Development Services again. I apologize. Thank you.
Yes, sir.
There was a lot of talk and specific comments about council members taking bribes with no evidence whatsoever of that. So, there was a lot of comments about what could be and very well could be.
I'm sorry, this is a public hearing. Please keep the comments.
It's on record. If you want to make a statement, please ask permission of the chair.
There was a lot of comments that directed us towards the issue of abortion. We had a big picture of it, what that is, what it looks like. A letter from the Archbishop was read. Certainly that's not the purview of this board, nor has any development services staff, including the building official and any of us, made a decision as to whether abortion is right or wrong. That has not come out of our mouth, but clearly it came out of the mouths of several of the people that came up and spoke. So these are a lot of the things. I think that's pretty much it. There was a comment about this building being a monument of mass stupidity. I'm not even sure how to respond to that. I know Mr. Lighthouse then made three times asked you to deny the appeal. I think he actually meant he wants you to support the appeal, but we may need to ask him on that one. And then a lot of discussion about integrity and children and rubber stamping and accomplices, like this big shell game, like this big conspiracy. But again, nothing has happened or nothing has been brought to you to say, you know that plumber? He was not licensed. Hey, that water heater? That's not the right water heater. Those type of things. That's what we're here to talk about today. So a very complicated couple-hour discussion really boils down to this. Are those plumbing permits okay? Are those water heaters going to be installed or have they been installed? And do we do our due diligence, the city, to review and make sure that permit was issued correctly? And the answer is yes. We reviewed the project back last summer. Our system is such that later on, the trade permits are pulled. We could do it all up front. We could have issued all of them at one time. Of course, that's not our policy and procedure, right? We do that with residential permits because it's different. But, so that all those things that were not related to what you heard, I just want to remind you, we're here to talk about, did we issue the permit, the City of San Antonio Development Services, did we issue those two permits in accordance with Chapter 10? And the answer, of course, is yes. So I'll stand on that.
Mike, I have a question for you.
Sure.
I think in your opening statement, you said that the permits have been issued, the work has been completed and inspected.
That is correct.
Make sure that we all understand that a permit which is being contested, that the work is completed, done, and inspected.
That is correct.
Are there any questions for Mr. Shannon from the board?
Mr. Chairman, I'm not sure if I should be asking the lady for Mr. Shannon. Why are we not, building permit is not being addressed as far as we're talking about plumbing. I understand the way it works is you have your building permit. At that point, everything is reviewed, checked off, ruled on, etc., approved. Once that's done, then the child permits are linked up to the building permit. All that's been done. The zoning issues and all that, the child permit's not addressed, it's addressed on the building permit. That's why all the trade permits are linked to the building permit. Is that correct?
The trade permits for a particular project, with this one included, when they're pulled, whether it be here in person or online, they get linked to the parent permit, which was, again, remember, the overall building permit is the one where we say, does this comply with city codes? And that's when we have the building review, electrical, zoning, traffic, et cetera, et cetera. Some of those things are Chapter 35 things, of course. Some of those things are Chapter 10. Some of those things are Chapter 11, the fire code. So we review all that at that time. As the child permits are pulled, i.e. the trade permits, it could be fire sprinkler, it could be plumbing, it could be electrical, all those other things. The particular licensed contractor says, I'm a licensed contractor according to the state rules, and I will install what was designed. That's generally how it works. So they are linked. But the answer to your question is, in general form, the other rules in Chapter 10 say, just like any other appeal process, there is a timeliness of appeal. Right? So when we issued the building permit, if they wanted to address the building permit in any of those decisions, there's a timeliness of appeal which says you have a certain amount of time to appeal the decision of the building permit. That would be appropriate in any type of appeal. I'm not a legal expert in terms of the law, so you can ask some of the attorneys about that. But if we didn't have something like that, could you imagine a building being constructed and open for 10 years, and then someone, 10 years later, say, hey, I know they're going to replace the water heater, but I want to appeal the building official's decision that this was zoned properly, and this, that, and the other, and what have you. So that's a very extreme example of what it could look like if we didn't have those things, but I think that kind of gets to your question of why they haven't, because they know that it's not timely. So I'm sorry, they know it's not timely, meaning they passed their time to do that.
Any other questions from Mr. Shannon? Thank you.
One other question, Mr. Chairman. Plaintiff was claiming that the department refused to let this go to the Board of Adjustment. Is there a reason why? What's the procedure on the Board of Adjustment?
Well, the plumbing permit would be heard by this board, right? If we're arguing the plumbing permit, that's what they said, they will argue the plumbing permit. Certainly, as they have indicated, they have attempted to argue the zoning of this project, i.e. as part of the building permit. They didn't meet the timeliness of that. And I'll have to look to my attorneys to double check the scenarios. The timeliness wasn't met. They argued that in a court of law. The court of law ruled against them because, of course, it wasn't timely and they didn't have that opportunity. So that's where right now, although there's some pending litigation as well on the project, where there's other avenues to handle that. So.
Thank you, Mike.
Yeah.
I inadvertently overlooked Mr. Robert Berry, who wanted to speak during the public session.
My name is Robert Berry. I reside at 4915 Bell Ellen, which is in the Green Hills State residential section. I am a retired professional engineer with over 60 years experience as a mechanical and electrical engineer. And the plumbing issue addressed by ordinance 2011-05-12-0378, amending chapter 34 of the San Antonio City Code by adding a section to address the discharge of fats, oils, and grease into the city sewer system. And it says in that section, Division 5, Section 34-525, fats, oil, or grease, any animal, vegetable, or mineral fats, oils, or greases, and any organic chlor compound derived from animal and or plant sources and contain multiple carbon chain triglyceride molecules shall be not discharged into the sanitary source. less carbon triglycerides is heat waste. Of more importance to me, since I think it covers the trap. Has anybody heard about the ambulatory surgical center licensing rules for the state of Texas? Does the city of San Antonio follow those things? I would think if it's state law, San Antonio is going to follow it also. But under one of the sections, areas requiring fully ducted systems are systems that provide critical care, sensitive care areas, all patient care areas, all areas requiring a sterile regimen, clean storage rooms, and where required for fire safety purposes. Combination systems utilizing both ducts and plenums for movement of air in these areas shall not be permitted. Ductwork access panels shall be labeled. If you don't have a copy of the ambulatory surgical center licensing rules for the state of Texas, which I'd ask Mr. Garcia, has ever seen that? You ever seen that?
So we're here to look at the codes as applicable to the city of San Antonio. Those regulations would have to be followed by the design engineers, and they would have to, I would assume, go through the process with the state to make sure that's compliant. So that's, if I'm correct, that's not in our purview. That's something that they have to follow, but you know, we stick to the ordinances passed here in San Antonio. That is the governing bodies of our board. And yes, you did mention some HVAC and plumbing things. However, these specific permits do not address those items either. It's a natural gas, I think the ones are a water heater, so that wasn't discussed. So.
Just having Mr. Derek, time's up. Thank you, gentlemen, and ladies, for hearing this.
Mr. Gerard, your final comments?
Thank you, Mr. Chairman. I know it's been a long day. I'll make them really brief. Mr. Shannon was referencing process and procedure in reference to some of our issues that we had raised earlier. I think what I was trying to tell the board is how it felt. And I gave the board an example, 2 hypotheticals of how it would feel regarding counsel for the city. And I also talked about process and procedure as was handed to us by the city. And when Mr. Shannon said that's something we need to look at, I will tell you, you as a board can establish your own processes and procedure by vote, and I would urge you to do that. You do not need Rod Sanchez or Mike Shannon telling you how to do that. It does not need to be regarding what Mr. Shannon was indicating about the permit, here's the bottom line. The bottom line remains, and it's been referenced by me, it was referenced by Mr. Wheeler, Mr. Knufke, by a number of others, it's in the letter, and it's this. Chapter 10 specifically says that they have to do a review for all applicable and pertinent laws, any and all laws. And no one on that table over there has explained to you why that doesn't matter, with one exception. Early on, Mr. Shannon said, that's for things under our purview. He just was back up here. He didn't explain why Chapter 35 is not under the purview of DSD, because he can't. It's silly. It is under the purview of DSD. So you are allowed to review under Chapter 10 any and all applicable laws for the issuance of the permit that were under the purview of Rod Sanchez and Mike Shannon and all of their employees. And that's in Chapter 10. And that's the reason he didn't come back to address that. The reason that the place is improperly zoned, we discussed at the last hearing, it's contained in the letter, and earlier I believe I was telling you, I was asking you to take a look at the example that we cited from the code, and I was referencing you to page 4 of our letter. It's actually at the bottom of page 3. I misspoke. I apologize about that. Right from the code in terms of the nomenclature. Here's the bottom line.
We showed you at the last hearing that the city has admitted in a letter from Trenton Robertson on December 22nd, 2014, that this location is improperly zoned.
Point of order, that's new information, not rebuttal, Mr. Chairman.
As contained in our letter, we are referencing that this area is improperly zoned because a C1 cannot be zoned for an ambulatory surgical center. That's what we've discussed. Their response has previously been, hey, you know what, we get to do a materially similar use. And we explain in our letter, and at the bottom of page 3, we specifically cite an example out of the code why that's a no-go, why that cannot be. So last time, 5 of you were in agreement on that. I asked that at least the same 5 and even some more be in agreement with us again. You have jurisdiction over this matter. This location is being improperly zoned. Those permits should not have been issued for an improperly zoned location, and we ask you to please reverse the decision of Rob Sanchez.
Is there any discussion amongst the board?
We take 5.
Let's take a 5-minute break.
Mr. Chairman, I was going to clarify something with our Pastor Plummer friend down at the end. I think he was indicating. Can you explain the process? There is no human waste that goes into the sewer system.
This material is collected and disposed of separately.
Are there any other questions before the board, amongst the board members?
Mr. Chairman, I do have one kind of statement. It troubles me that I do believe that there is a zoning issue. The problem is that at this point, the zoning issue has to do with the building permit, from my understanding. I tend to think that since there are other permits tied to it, that doesn't mean, in my mind, the building permit is still active. It doesn't seem quite right that there's no recourse at this time to appeal that decision. I think this board is put in place to rectify mistakes that do happen. I believe that honest people do make mistakes, and that we're here to, as a balance, to rectify those mistakes. And I would like to, this board is a technical board. We talk about fire lanes, CFM, lengths of air duct, and stuff like that. We are not zoning guys. But I would like to make a motion that we direct the zoning matter to the Board of Adjustment for review. And if they find that the zoning is correct, the permit stands. If they find the zoning is incorrect, we come back and discuss the validity of the decision of the director.
Mr. Shannon, correct me if I'm wrong, but I think you mentioned that this matter has already gone before the Board of Adjustment, reviewing the zoning issue.
No.
No, that's not correct.
What is it that has been done relative to the original permit?
The land use question, or the zoning question, is currently in process in the legal court proceeding, not through the Board of Adjustment.
Thank you for the clarification.
Point of order, Mr. Chairman. That is in litigation because it's been denied to be heard at the Board of Adjustment by the DSD Director's Office.
Thank you for your comment. Mr. Curley, did you make a motion?
Yes, sir, I did.
Please restate the motion.
I would ask to make a motion to direct the Director of Development Services to forward this matter of the zoning to the Board of Adjustment for review. And if they find that the zoning is correct, the permit would stand. If it is incorrect zoning, then we deny it or revoke the permit. Think about that now. For review, and if it's incorrect, that we grant the plaintiff's review.
Is there a second?
Ron Cagle, second.
There's a motion that's been made and seconded. The motion is to direct the Director of Development Services to refer the zoning issue to the Board of Adjustment for review. Correct, Mr. Curley?
That's correct.
Mr. Chairman, question. And I don't know who this would be directed to, but is there any legal basis that would compel them to actually go ahead and take that reference? And if there isn't, are we just kind of kicking this out into oblivion?
The answer to your question is no.
What was that, Tim?
The answer to his question is no.
I guess my point was, we can, if hypothetically we pass this motion, I'm sorry, this is Mike Russ, multifamily, for the record. If we pass this motion to refer this to the Board of Adjustment and there's no legal requirement that such a recommendation be adopted, that they actually hear it, what we're in effect doing is passing this out into the ether, never to be redeemed.
Thank you for making that clear. So, any other discussion?
Garcia, can we actually make motions that require hearings before other boards? Is that something within our power to do?
No.
Legal has advised us that as a board, we cannot make a motion to compel another board to hear an issue.
Excuse me.
Just a moment.
Point of discussion, Jack Upworth versus the contractor. So we're now in a zone where we don't know if we can make this motion or not make this motion. The motion's been made and seconded. So if we pass it or don't pass it, if we pass it, then it goes and they figure that out.
That's right.
The legal part of this.
We could pass the motion and it would actually not accomplish anything. Basically what I've been told. I understand. With that in mind, we've got a motion made and seconded. Call for a vote. All in favor, right? All in favor of a motion to require the director of DSD to forward the zoning issue to the Board of Adjustment?
Point of order. For clarification, due to the ordinance that was changed January 29, to answer your question, Mr. Chairman, point of order, my name is Patrick Mondola, San Antonio Family Association. Sorry, Patrick Mondola, San Antonio Family Association. Point of order that was alluded to that there's no recourse that you kicking the can down the road. The fact of the matter is that because the ordinance was changed on January 29th of this year, that limits due process to residents, to citizens. You make a decision to do this. It sends it to the Board of Adjustments, which there is an appeal process. It does give due process to the residents of Dreamville Estates. By taking the vote, and if you approve the permit, then there is no course of action. There is no due process to citizens. So it's not kicking it down the road. It's giving the citizens, residents of Dreamville Estates, an opportunity to be heard before the proper boards, and if need be, before the mayor and city council. That's what your vote on this motion, this good motion, allows the citizens to do in the Dreamville Estates residents.
Mr. Chairman, I think the point is that I was making is that regardless of any opinion of whether we can or can't pass a motion, whether or not we're allowed to, regardless of that, if we did pass that motion, I don't know that there's any law written anywhere on the books that requires the Board of Adjustment to actually listen to a motion that we pass. And that was my point, was that I could scream from the mountaintop for them, hey, you should listen to this. But there's nothing legally requiring them to do that. And that's my point, is that I don't want the resolution of this to be an action that, in effect, is no action.
Sure, may I address it? Mr. Rust, I would tell you that there's always higher courts. We don't know always the limitations or authorities. And if we don't know the limitation of authority of our own board, because it's been possibly subverted by the management of the department that's kept you in the dark, is that the best way to bring it to the light is to send it to the next higher board. The second is, if you ever go in a civil court, if two people decide that they don't want to be married anymore, there's a higher court, and they don't determine whether or not that if they're legally divorced or not. You can't do that. There's common law marriages, but there's not common law divorces. You have to go to court and settle that. And so in this case, I would tell you there's a higher authority that can make the decision. They'll come back and tell you that it's whether it's proper or not for you to make that determination. If they don't, give them that chance. Thank you.
Mr. Chairman. The Board of Adjustment is not a higher authority than this board. You're on equal terms. If the citizens want due process after this board's decision, their due process is to the local district court.
And Mr. Chairman, if I may, I can read to you what we have in our code that addresses, I think, the overall question. Under the Chapter 10, when it talks about the Board of Appeals, under limitation on authority, the Appeals and Advisory Board, this is item number 3. The Appeals and Advisory Board may also review and make recommendations to the building official or fire chief on any building-related or fire code issue, as requested by citizen or board member when the request for board is approved by the building official or Appeals and Advisory Board chairman. So again, I think the answer to Mr. Rush, your question, and even Mr. Curley, what you were referring to is, you can make a motion to make a recommendation to us to do something, meaning the building official or fire official, but that's what it is, it's a recommendation. So, but that's clearly spelled out in our Chapter 10 ordinance. I think if you word it such that we direct the building official or fire code official, that I don't think you have the authority to do. Which I know if you don't have the authority to do that, because I just read it. So again, feel free to make recommendations. That would be under your charge and limitation on authority. But if you want to discuss that further amongst yourself, and we can, if we need to, we can put that on the screen for you or something.
Mr. Curley, would you?
I'd like to modify my motion as a recommendation.
project must continue to support.
So the motion is that this board recommend to the Director of Development Services a recommendation to refer the zoning issue to the Board of Adjustment. Is that correct?
That is correct.
Moved and seconded. Any discussion amongst the board?
Garcia? So if the recommendation passes, it would be so that they can review it, but if, let's say, they maintain their same position where that, the decision was proper and so forth, then we're technically still left with these two permit appeals.
I may be wrong, and Mr. Shannon can clarify that. I think they have to follow the letter of the law that says 30 days. So that is their purview to go back and change it if they like. At least by this motion, I believe it gives them the authority to move it to the adjustment, Board of Adjustment.
Is there any other discussion amongst the board?
Yes.
But if we go back to the 30 days, the original 30 days of the building permit?
My understanding is the building permit, which is when the zoning is done, the zoning review is done. The time to appeal that is why the plaintiff is not brought up in the building permit, because the 30 days of appeal is passed. We're just saying we recommend the director to have the Board of Adjustment review the zoning.
One more point of order, just quickly, Mr. Chairman. I know you did close the open portion, but you did ask some questions to both staff, and I know one of the gentlemen right here answered some questions for you. Can you please just clarify when the open portion is closed again, so the board can have their discussion? I think it's just getting a little unclear. Meeting's going to have to take these minutes, so I just want to make sure. And she'll be going through the video and the audio. I'm sorry. So please, thank you.
To call the question.
Thank you for that. The discussion on the issues should have been closed after Mr. Duart's comments. This time is for the board members to discuss the issues. Again, I'll repeat, we have an amended motion to recommend to the Director of Development Services that the zoning issue be referred back to the Board of Adjustment. It's made by Mr. Curley and seconded by Mr. Cackamason.
Chairman, before we take the vote on this, I just have one question. The original charge here was to validate, according to Chapter 10, the two plumbing permits, whether they were issued correctly. So my question is, because it has a difference on how I'm going to vote, does that mean that we cannot consider that motion if we take Mr. Curley's motion?
No, we have a motion on the floor that we need to act on. We'll act on the plumbing permit question after that this motion is resolved. That statement, I'd like to call for a show of hands. Vote all in favor of Mr. Curley's motion. All opposed? Thank you. Motion carries. Now, we need to...
Though I know that this body probably doesn't meet all the needs of the people that who got up and spoke, because we have very limited charge of what we can do. And what the applicant did distribute is the applicant requirements, and I just want to read it and then I'll make my motion. The true intent of the burden of proof is the true intent of chapters 10, 11, and specific articles in chapter 28. The rules legally adopted there have been incorrectly interpreted. In absence of seeing anything related to these two building permits that were issued, that I move that we uphold the city's process on the issuance of those two permits that were issued correctly
raise your statement.
Yes, sir.
Mr. Hanley has moved that we uphold the director's decision regarding the 2 plumbing permits. Is there a second?
Second.
Moved and seconded.
Mr. Chairman, you said plumbing permits, right?
Yes. The issue before the board today is 2 plumbing permits. Any discussion amongst the board? All in favor of upholding the director's decision, please raise your hand. All opposed? Motion carries. Next order of business is city staff reports.
There is no additional city staff report today. Thank you.
Are there any comments from the board?
I move we adjourn, Chairman.
I would second that motion.
Mr. Hanley moved for adjournment, seconded by Mr. Curley. All in favor say aye. Aye. All opposed?
No,